My stepbrother sent me a photograph of a deed. He sent it on a Tuesday afternoon with no message preceding it, just the image, and then a second message that said, "The farm is mine, and I have the deed, and if you want to talk about it, you can call me." The deed was a warranty deed. It listed my father as grantor and my stepbrother Garrett as grantee, and it was dated July of 3 years before my father died, and it was notarized, and it appeared from the photograph to bear the Wayne County Recorder's stamp. The photograph was not a clear image. It was taken at an angle, the way you photograph a document on a table without picking it up, and some of the text was in shadow. But the date was visible, and the names were visible, and the recorder's stamp was visible, and the implication was clear. He was saying that my father had transferred the farm to him 3 years before he died, and that the farm was therefore not part of the estate, and that anything I might have expected to receive from it was not coming to me. I did not call him. I want to describe the specific quality of reading the text message that Garrett sent and what the 40 minutes that followed it felt like. I am a staff accountant, and I work with financial documents and numerical sequences every working day, and I have the specific habit of a person who has trained herself to read documents before reacting to them. The photograph came through on a Tuesday at just past 2 in the afternoon. I looked at it and I read the date and I read the names and I saw the recorder's stamp, and I did not respond to Garrett's follow-up message. I opened the Wayne County Recorder's website. I typed in the parcel number that I had in my notes from the estate administration process because I am a person who keeps the relevant numbers in their notes. The results loaded. I saw the deed. I saw its recording date, which was 5 days earlier, 4 months after my father's death. I kept reading. I found the mortgage entry. I found the TOD entry. I wrote the dates down. The dates were not ambiguous. The dates were not a matter of interpretation. The dates were the public record, and the public record said clearly what had happened and in what order it had happened. I called Alice's voicemail. I went to bed. In the morning, I called Philip. The sequence had already told me everything I needed to know. Wayne County Recorder's website. I work as a staff accountant for a manufacturing company in Worcester, and I have worked with financial documents my entire professional life, and I have the habits of a person who verifies things before reacting to them. The Wayne County Recorder has an online portal that allows you to search recorded instruments by name or by parcel number, and I had used it before because my father's farm is in Wayne County, and I had looked at the property records when we were discussing estate planning. I searched my father's name. I found the deed. I found the recorder's stamp dated to the preceding Tuesday, which meant Garrett had recorded it 5 days before he texted me the photograph. I looked at the deed entry in the index, then I kept scrolling, and I found 2 more entries for the same parcel. The first additional entry was a mortgage recorded 18 months after the deed's stated date, a refinance mortgage showing my father as the borrower and the property as collateral. The mortgage had been executed by my father at a closing with the bank. If the deed had been valid and my father had transferred the property to Garrett in July of the year shown on the deed, then my father had not owned the farm 18 months later. Banks do not lend money against property the borrower does not own. They conduct title searches before closing. A title search would have found the deed. The bank had conducted no such title search because they had found no such deed, because in the 18 months between the alleged deed date and the mortgage closing, the deed had not been recorded. The deed existed now. It had been recorded last Tuesday. It had not been recorded 18 months after its alleged execution date, when my father went to a bank and used the farm as collateral for a refinance and the bank approved the loan. The second additional entry was a transfer on Death Affidavit. It had been recorded 14 months after the alleged deed date and 8 months before my father died. It was executed by my father, and it named me as the sole beneficiary. The TOD affidavit designated the farm to transfer to me automatically upon my father's death. Under Ohio law, a property owner can execute a transfer on death affidavit designating a beneficiary for real property. Only the owner can execute such an affidavit. If my father had transferred the farm to Garrett in July of 3 years ago, my father had not been the owner of the farm 14 months later when he executed the TOD affidavit. You cannot execute a transfer on death affidavit for property you do not own. My father had executed one. It was in the public record. It had been recorded, and it was there in the deed index, 14 months after the alleged deed, 8 months before his death. Before I go on, if this story I want to explain what a transfer on death affidavit is and what a warranty deed is and how they interact in the specific situation I am describing. A warranty deed is a document that transfers ownership of real property from one person to another. When a warranty deed is validly executed and recorded with the county recorder, it establishes in the public record that ownership has transferred. After a valid warranty deed, the grantor no longer owns the property. A transfer on death affidavit is a document that designates who will receive a property upon the owner's death. Only the current owner can execute it. If a person has already transferred a property by warranty deed, they are not the owner and they cannot execute a TOD affidavit for that property. The county recorder will not accept a TOD for property the person does not own because the title chain would not support it. When my father went to Alice Fair's office and executed the TOD affidavit, the recorder accepted it because the title search showed my father as the owner. There was no warranty deed on record showing any prior transfer because no such deed existed yet. The deed Garrett recorded 4 months after my father's death was dated to a period before the TOD and before the mortgage. But the record showed none of those transactions working the way they should have worked if the deed had been real on the date it claimed to be real. Connects with something real in your life, please take a moment to like and subscribe, but only if you genuinely feel it. Drop a comment and tell me where you are watching from and what time it is there. I read every single one. My name is Vivienne. I am 35 years old. And this is the story of how a Wayne County Recorder's deed index, a mortgage closing record, and a transfer on death affidavit that my father had filed 8 months before he died and that had been sitting in the public record ever since told me in about 40 minutes everything I needed to know about the deed Garrett had just recorded, and what happened when an attorney named Philip Ortega put those 3 documents in front of a judge in Wayne County Common Pleas Court. Now let me take you back to the beginning, not the Tuesday afternoon text, before that. To the farm in Paint Township in Wayne County, Ohio that my father had owned for 39 years and that he had purchased at 36 years old and that had been, for the last 39 years of his life, the center of what mattered most to him. Wayne County is in northeast Ohio, in the part of the state where the land is rolling and varied and where agriculture has persisted with the particular persistence of communities that have organized their identity around the land itself. The county seat is Worcester, which is where I live and work, and the farm is in the western part of the county in Paint Township, which is a rural township with the specific character of a place where people have been farming the same land for generations and where the names on the mailboxes have been on the mailboxes for a long time. My father's name was Dennis. He died at 75 of a respiratory illness that had taken 18 months to take him, the slow kind of dying that gives you time to say things and do things and arrange things before the end arrives. He was a soybean and corn farmer who had also run a small equipment repair operation out of the farm's outbuilding for 30 of his 39 years on the property, and who had the particular quality of knowledge that comes from 39 years of working a specific piece of land. The knowledge of its drainage patterns and its soil variations, and which fields performed in wet years and which performed in dry years, and what the equipment needed in which season. He knew the farm the way you know something you have spent 39 years paying close attention to. The knowledge was specific and irreplaceable, and it died with him. Garrett is my stepbrother. He is 42. His mother and my father married when Garrett was 14, and I was 8, and the marriage had lasted 11 years before my stepmother died of cancer. Garrett and I had been in each other's lives for 24 years and had the specific relationship of people who became family through adult arrangements rather than shared childhood and who have managed that relationship with varying degrees of success and warmth over 2 decades. He had been more proximate to my father than I had been in the last years of my father's life, partly because he had moved back to Wayne County after a period in Columbus, and partly because the proximity had come with the specific advantages of being present for the daily decisions and the ongoing conversations that shape a person's understanding of what is wanted and who will receive it. My father had made the transfer on death affidavit in consultation with his estate attorney, a woman named Alice Fair, who had an office in Worcester and who had handled my father's legal affairs for the last decade of his life. Alice had told me at a meeting I had attended in the 2nd year of my father's illness that he had already taken care of the farm with the TOD affidavit and that the farm would pass directly to me without going through probate. She had shown me the recording date and the parcel number and had said the record was in order and the transfer would be clean. I had not thought about the TOD affidavit again until the Tuesday afternoon text. I had not needed to think about it. The record was in order. It had been in the public record for 18 months. It had been there before my father died. It was there after he died. Nothing had changed it. What had changed was that a deed had been recorded. A deed dated 3 years before the TOD affidavit, from before the mortgage, from before any of the other entries in the recorder's index that showed my father continuing to act as the owner of the property after the date when Garrett was claiming the ownership had transferred. I called Alice the morning after the text. She said she had already been notified about the deed by the title company processing the estate and that she had been expecting my call. She said the situation was exactly what it appeared to be, and that she was going to refer me to Philip Ortega, who handled contested property matters in Wayne County and who had 17 years of experience with deed challenges. She said Philip would know what to do with this and that I should call him today. I called him that afternoon. Philip listened to what I described and said nothing for a moment. Then he said, "You have already found the mortgage and the TOD." I said, "Yes." He said, "When did you find them?" I said, "Last night, within an hour of receiving the photograph." He said, "Send them all to me, the deed, the mortgage entry, and the TOD affidavit." I sent them from the recorder's portal within the hour. He called me back. He said, "This is a case where the deed refutes itself." He said the deed is dated in July of 3 years ago. The mortgage is dated 18 months later. The TOD is dated 14 months after the deed. He said if the deed had been valid, the mortgage would be fraudulent because my father could not have borrowed against property he had already given away. He said the bank had done a title search before closing the mortgage and the title search had not found the deed, which means the deed was not in the recorder's office at the time of the mortgage closing. He said the TOD is even more direct. He said your father executed a transfer on Death Affidavit designating you as beneficiary of property that, if the deed were valid, he had not owned for 14 months. He said the recorder accepted the TOD because the recorder did not find the deed because the deed was not there. He said the deed was created after the mortgage and after the TOD and was recorded last Tuesday after your father died. He said the date on the deed is false. Philip filed a complaint in Wayne County Common Pleas Court to void the deed. He submitted the deed. He submitted its recording date from the Wayne County Recorder last Tuesday, 4 months after my father's death. He submitted the TOD affidavit with its recording date 14 months after the deed's stated execution date. He submitted the mortgage with its closing date 18 months after the deed's stated execution date. He submitted the title commitment from the mortgage closing, which showed no deed transferring ownership to Garrett had been on record when the bank approved the loan. He submitted a sworn statement from Alice Fair about the TOD affidavit preparation and her meeting with my father and my father's stated intentions. He submitted my father's death certificate and the probate case filing date, establishing that the deed had been recorded 4 months after my father's death. He submitted a statement from the Wayne County Recorder's Office confirming the recording dates of all 3 instruments. Garrett's attorney filed a response. I also want to describe the moment when Philip Ortega said the deed refutes itself because I think that phrase captures something important about this specific kind of case that is worth articulating clearly. A fraudulent deed that is presented alone requires external evidence to establish its fraudulence. You need a witness or an expert or a comparison or some independent fact that contradicts the document. But a fraudulent deed that is presented in the context of a complete recorder's deed index for that parcel is a document that is presented alongside its own refutation. The index already contains the evidence that the deed is not what it claims to be. The TOD affidavit was in the index before the deed was recorded. The mortgage was in the index before the deed was recorded. The deed arrived into a record that already told the story of what had actually happened, and the deed did not fit that story. Philip said when I first asked him how he would approach the case that he would simply put the 3 documents in sequence and explain why the sequence could not exist if the deed were real. He said the judge will see it. He said judges who handle property matters have seen this pattern before. He said the record is the argument. He said, I just need to present it in the right order. He presented it. The judge saw it. The ruling was correct. The record had been the argument since the day the TOD was filed. Arguing that the deed was valid and had been executed by Dennis and had been in Garrett's possession since the execution, and that Garrett had simply delayed recording it, and that the delay did not invalidate the deed's execution. The argument addressed the recording date directly. It said Ohio law does not require a deed to be recorded immediately, and that a deed is valid upon execution whether or not it is recorded. This is a correct statement of Ohio law. Philip acknowledged it in his reply. He said Garrett was right that a deed is valid upon execution and that the failure to record does not automatically invalidate it. He said what invalidated this deed was not the late recording, but the evidence that the deed had not in fact been executed on the stated date. He said the mortgage was the central piece of evidence. He said a bank conducting a mortgage closing performs a title search specifically to identify any prior transfers of ownership. He said the bank's title commitment from the mortgage closing showed a clean title with no transfer to Garrett, which meant either the bank had conducted an incompetent title search, which was contrary to the documentation of the search, or the deed did not exist at the time of the mortgage closing. He said the TOD affidavit made the same point. He said a person does not execute a TOD affidavit designating someone else as beneficiary of property they believe they already transferred. He said my father had sat in Alice Fair's office and discussed the farm and its intended disposition and had executed the affidavit naming me and had done so as the owner of the farm because he was the owner of the farm. He said the internal contradiction between the deed's stated date and the subsequent record of my father's continued ownership was not a coincidence of timing. It was evidence of a false date. The case was assigned to Judge Sandra Novak, who had been on the Wayne County Common Pleas bench for 8 years and who had handled contested property matters in Wayne County for the full duration of her service. She requested the original deed for examination, and she requested the mortgage file, and she requested the county recorder's chronological index for the parcel number going back 10 years. She reviewed all of it. She set a hearing. At the hearing, she asked Garrett's attorney one question. Can you produce any evidence that the deed was in existence before the mortgage closing? Any evidence at all? Not a recording. Any evidence? A contemporaneous communication about the deed. A witness to the execution. Any documentation from the period between the alleged execution date and the recording date. The attorney said he did not have such evidence available at this time. Judge Novak said she had reviewed the mortgage file and the title commitment and the TOD affidavit and the deed index, and she had reached a conclusion. She said the conclusion was not complicated. She said if the deed had been executed in July of 3 years ago, there would be some evidence of its existence in the 3 years between its alleged execution and its recording. A title search would have found it. A TOD affidavit executed by the grantor would not have been possible. A mortgage against the property would not have been approved. She said none of these things happened the way they would have happened if the deed had been real. She said the deed was not real. She voided it. The farm remained with the estate. The TOD affidavit remained effective. The farm transferred to me. The farm is mine now. I have not a want to say something about the relationship between accounting work and document verification, and why the skills I use at my job were directly applicable to what I found in the Wayne County Recorder's portal. Accounting at its core is the practice of making sure that numbers in different places tell a consistent story, and that when they do not, you find out why. A balance sheet that does not balance is not a matter of opinion. It is a fact that requires investigation. You find the source of the discrepancy and you trace it until you understand it. What I found in the recorder's portal was a balance sheet that did not balance. The deed claimed a transfer in July of 3 years ago. The mortgage was dated 18 months after that. The TOD was dated 14 months after that. You cannot refinance property you do not own. You cannot file a TOD for property you do not own. The numbers did not tell a consistent story. The deed was the entry that had been added to the ledger to make the balance sheet say something it had not previously said, and the other entries that had been there before it were the entries that showed why the new entry was wrong. You trace the discrepancy to its source. The source was the deed. The deed did not exist on the date it claimed to exist. The other documents had been created while my father was alive and while he was the owner, and those documents were real. You trust the documents that were there before the problem arrived. You find the one that does not fit. That one is the answer. My father would have understood the accounting metaphor because he kept books for his repair shop with the same discipline he kept the crop records. He knew that a ledger that does not reconcile is telling you something, and that the correct response is to find out what. He never let a discrepancy sit. He always found the source. He raised a person who does the same thing. The deed was a discrepancy. I found the source. It took about 40 minutes. Been there since the day after the ruling because I have been managing the other aspects of the estate, and because going to the farm and knowing it is mine and not yet knowing what to do with it is something I have been approaching carefully. I know what the farm looks like. I know the fields by their informal names, the names my father used that referred to their specific characteristics or their history. I know the outbuilding and the equipment inside it and the way the equipment is organized, which is organized the way a person organizes things when the organization reflects their understanding of what the work requires. I know the specific quality of the light over the western fields in the early evening in September. I know the farm. It will be there when I am ready to go. Garrett and I have not spoken since the ruling. I hold this with the specific patience of someone who knows that the correct thing was determined and who does not yet know what to do with the 24 years of relationship that preceded the Tuesday afternoon photograph. My father had a version of Garrett that he had held in some compartment separate from the farm and its intended disposition, and I believe he had made peace with both versions in the ways that parents make peace with the complicated realities of the children they have raised. I have not yet made peace. I am working on it. I want to say something before I go, not about Garrett and not about the prosecutor, about the deed index and what it is and what it showed me in 40 minutes on a Tuesday night. The Wayne County Recorder maintains a public record of every instrument filed with the office that affects the ownership and encumbrance of real property in Wayne County. You can search it by name or by parcel number. When I searched by parcel number, I got the complete chronological history of every recorded instrument for that specific piece of land. The deed from when my father bought the farm in the 80s, subsequent instruments over the decades, the mortgage from when he refinanced, the TOD affidavit he filed 8 months before he died, and then last Tuesday, the deed Garrett had recorded, the complete history in chronological order. The deed did not fit the history. A property you have transferred cannot be refinanced, and its transfer cannot be designated to a third party 14 months after you allegedly gave it away. The internal contradiction was visible in the sequence of the index. You did not need legal training to see it. You needed to read the dates. Thank you for staying until the end. If this story made you feel something, write it in the comments. I read every single one. And if you want to hear the story of a woman whose cousin had been collecting rent from her late aunt's duplex for 11 months before the estate was even opened, and what the county auditor's property tax records showed about who had been listed as the responsible party for the property tax during those 11 months, it is waiting for you in the description below. Click it. Until next time, take care of yourselves. And if someone presents you with a deed to property that belonged to a family member, search the county recorder's deed index for that parcel number and read every instrument in the chronological order. Look at the dates of every entry. Look for instruments that the grantor filed or executed after the deed's stated date. If you find a mortgage or a transfer on death affidavit filed by the grantor after the date they allegedly transferred the property, you have found what the record says about when the transfer actually happened. The sequence is the whole answer. I want to describe what the Wayne County Recorder's portal looks like, and I want to say something about what you can do if you are in a situation where someone has presented a deed to family property and you have reason to question its authenticity. The first thing to do is search the county recorder's portal for the parcel number of the property. You can find the parcel number in the county auditor's property search if you do not already have it. When you search the parcel number in the recorder's portal, read every entry in the chronological index. Read the instrument type and the recording date for each one. Look for instruments that the alleged grantor executed after the deed's stated date. Specifically, look for mortgages, refinances, transfer on death affidavits, and any other instrument that only an owner can execute. If you find any such instrument, compare its date to the deed's stated date. If the grantor was taking ownership actions after the date they allegedly transferred the property, that is the internal contradiction that makes the deed refute itself. Then look for any mortgage and pull the title commitment if you can get it. The title commitment will tell you what was in the record at the time of the mortgage closing. If the deed was not in the title commitment, the deed was not in the record when it should have been if it were real. The portal is free. The parcel number is in the auditor's records. The search takes 20 minutes. The dates are everything. What the experience of using it is, because I want you to understand that this is not a specialized or difficult system, and that the information I found in 40 minutes is information that any person can find in the same amount of time without any professional assistance. The portal is accessible from the Wayne County Recorder's website, and the search is straightforward. You can search by the name of the grantor or grantee or by the parcel number, which is a unique identifier assigned to each piece of property in the county. When I searched my father's name, I got a list of every instrument he had ever recorded in Wayne County. And when I searched the parcel number, I got the complete chronological history of every instrument ever filed against that specific property. The entries show the instrument type, the parties, the recording date, and a reference number that allows you to pull the actual document. I pulled all 3 instruments within the first 20 minutes: the deed, the mortgage, the TOD affidavit. I read them in chronological order, and I wrote down the dates in a column on a notepad on my desk. Date of deed, July, 3 years before death. Date of mortgage closing, January, 18 months after deed date. Date of TOD affidavit, September, 14 months after deed date. Date of deed recording, last Tuesday, 4 months after death. I looked at those 4 dates for a long time, and then I called Alice's voicemail and left a message, and I went to bed, and I did not sleep well. I want to tell you more about my father and about what kind of person he was, because I think understanding who he was is important to understanding why what Garrett did is the specific thing that it is. My father was a precise man, not formal, not unfriendly, but precise in the specific way of someone who has spent 39 years working with the requirements of land and machinery and who understands that imprecision has consequences. He logged everything. The farm had a records cabinet in the farmhouse office, a 4-drawer filing cabinet that contained in organized folders 39 years of farm records, crop yields by field and by year, equipment maintenance logs with dates and parts used, property tax receipts, insurance policies, correspondence with the county extension office, and legal documents in their own clearly labeled section. The TOD affidavit was in the legal documents section in a folder labeled Farm Transfer with Alice Fair's name on the tab. I found it when I went through the filing cabinet after his death, and I held it in my hands and read it and thought about him sitting in Alice's office and executing it and filing it in the correct folder when he got home. He had not told me he was doing it at the time he did it. I had known in general terms that the farm would come to me because he had told me this in various conversations over the years in the way that parents tell adult children the general shape of what they are planning without always providing the specific details. When Alice had told me at the meeting that the TOD affidavit was in place and the record was in order, she was confirming what I had understood was the intention without knowing the mechanism. I had been glad it was handled, and I had not thought about it again until the text arrived. That is what it means to have your affairs in order. The people you intend to benefit do not need to think about it and do not need to worry about it because the document is in the record, and the record does not change. I want to say something about what the mortgage evidence means and why Philip described it as the central piece. When you apply for a mortgage in Ohio or anywhere in the United States, the lender conducts what is called a title search before closing. The title search is performed by a title company or an attorney who goes through the county recorder's deed. I want to say something about the title search process and about what it reveals in this context. When a lender approves a mortgage, they pay a title company to search the county recorder's deed index for the property going back a specific number of years to confirm the ownership chain. The title company produces a title commitment that says, in effect, we have searched the public record and we find the borrower to be the current owner of the property, and we find no undisclosed prior transfers or liens that would affect the lender's security. This commitment is the lender's protection. Without it, the lender does not close. When my father closed on the refinance mortgage 18 months after the deed's alleged date, the title company searched the index. They did not find the deed, because the deed was not in the index. Because the deed had not been executed in July of 3 years ago. The title commitment in the mortgage file was created contemporaneously with the closing. It was not a document created after the fact. It was a document created by a professional title company whose business depends on the accuracy of its searches and who had searched the public record and found exactly what was in the public record, which was my father's ownership and no prior deed. Philip said the title commitment is not just evidence. He said it is dated professional testimony that the deed did not exist when it should have been findable if it had been real. Index for the property and identifies every instrument ever filed against it. Prior deeds, mortgages, liens, easements, anything that might affect the ownership or encumbrance of the property. The purpose is to ensure that the borrower actually owns the property they are borrowing against and that there are no undisclosed claims against it. If there had been a deed on record showing that my father had transferred the property to Garrett 18 months before the mortgage closing, the title search would have found it. The lender would not have approved a mortgage on property my father did not own. The fact that the mortgage was approved and closed tells you that the title search found no such deed. The title commitment in the mortgage file was the documentation of that finding. It was the title company saying, "As of the date of this search, the property is owned by Dennis, free and clear of any prior transfers, and it is suitable collateral for this mortgage." The deed's alleged execution date was 18 months in the past at the time of that search. If the deed had been real, the search would have found it. The title commitment said it had found no such deed. The mortgage had closed. The loan had been made. The deed, as of that date, had not existed. I want to tell you about Philip Ortega and about what it means to work with an attorney who has spent 17 years on contested property matters in a county where he knows the court, the recorder's office, the title companies, and the ways these cases develop. Philip had a specific quality that I noticed from the first conversation, which is that he asked questions in the order that mattered rather than in the order that was easiest to ask. He did not start with what had happened. He started with what I had already found. When I said I found the deed, the mortgage, and the TOD, he moved directly to the sequence of dates, and he understood in the first 2 minutes of our conversation what the sequence meant and what it established. He was not surprised by the internal contradiction. He said cases like this, where a fraudulent deed refutes itself through the other instruments in the recorder's index, were not uncommon in contested estate matters, and that the fraudulent deed was almost always the instrument that had not been recorded when it should have been if it were real. He said a real deed gets recorded. He said people record deeds because recording is what protects the ownership. He said a deed that sits in someone's possession for 3 years while the grantor continues to act as the owner of the property, refinancing it and designating its disposition to someone else, is not a deed that was real when it was dated. He said you usually find what you found. He said the record shows you. I also want to describe the hearing in Wayne County Common Pleas Court, and I want to tell you about Paint Township and about the specific quality of the land in the western part of Wayne County where the farm is located. Wayne County is in the part of Ohio that sits at the transition between the flatter terrain of the Lake Plains to the north and the more varied topography of the hill country to the south and east, and the land has the specific character of a transition zone, with enough relief to give the fields varied drainage patterns and enough flatness to make row crop agriculture practical across most of the cultivated ground. Paint Township is rural in the particular way that rural Wayne County townships are rural, which is the way of places that have been farmed for a long time and that carry the specific legibility of land that has been worked by people who knew what they were doing. My father had been one of those people. He had learned the land in the first years and had continued learning it for 39, and the yield records in the filing cabinet are the documentary evidence of that learning over 4 decades. What the land needed and when it needed it and what it gave back when you gave it the right things. The record of that knowledge is in the cabinet. The land is mine now. I am not yet certain what to do with either one. I am in no rush to decide. The dates are in the index. The index is there. It has always been there. What it was like to sit in the courtroom and hear Judge Novak ask her question. Philip had told me to expect a short hearing because the evidence was documentary and the sequence was clear. He said Judge Novak was efficient when the record was sufficient and that he expected her to ask 1 or 2 targeted questions and rule from the bench. He was right about the efficiency. The courtroom had the specific quality of a room where significant things are decided in unremarkable surroundings, the same fluorescent quality and the same institutional furniture and the same ordered procedural rhythm that courts have in Wayne County, the same as they have everywhere. Judge Novak had clearly read everything. She asked her 1 question. Garrett's attorney did not have an answer. She reviewed the documents for 3 minutes. She ruled. The deed was void. The farm remained in the estate. The TOD affidavit was effective. I would receive the farm. I thought about my father during the hearing. I thought about him sitting in Alice Fair's office and executing the TOD affidavit with the specific care of someone who wanted the disposition to be clear and properly documented. I thought about him going home and filing it in the correct folder in the cabinet under farm transfer. I thought about the 39 years of organized records in that cabinet, the crop yields and the maintenance logs and the tax receipts, all of it dated and in order and findable. He had kept records his whole adult life because he understood that records were what protected the things that mattered. The TOD affidavit was a record. The recorder had kept it in the public index. The public index had preserved it through everything that followed. When Garrett recorded a deed 4 months after my father's death, the TOD affidavit was already in the index, already in the record, already saying what my father had decided and when he had decided it. The deed arrived too late. The record was already complete. I want to say something about the filing cabinet and what it tells you about the approach to documentation that my father had maintained his entire farming life. In the 39 years he owned the farm, he had created a complete written record of every significant thing that had happened to it. He had done this not because anyone required it, not because there was a system imposed from outside, but because he had understood from the beginning that the record was what allowed you to know where you were. If you wanted to know how the North Field had performed in the wet year of 2003, you looked in the yield records. If you wanted to know when the grain elevator had last been serviced, you looked in the maintenance log. If you wanted to know what the farm's intended disposition was after his death, you looked in the legal documents folder. The system was consistent and complete and available to anyone who opened the right drawer. After his death, when I opened the filing cabinet, I did not have to search for what I needed. I found what I needed in the place where it was supposed to be because he had put it in the place where it was supposed to be. I had the TOD affidavit in my hands 20 minutes after I began going through the cabinet. He had made it findable. He had always made things findable. There is something I want to say about what it felt like to discover the mortgage entry in the recorder's index. I had searched the parcel number and seen the deed, and my first response to the deed had been a combination of recognition and a particular kind of alert focus that I associate with the moments in accounting work when a number does not add up, and you understand that you are going to find out why. I was expecting to see the deed. Garrett had... There is something I want to say about what it means that the deed was recorded 4 months after my father's death. This fact is separately significant from the internal contradiction that Philip described. A deed that was executed 3 years before my father died, but that was not recorded until 4 months after his death, is a deed that was held in someone's possession through my father's entire illness and his death and the opening of the estate, and was produced and recorded when it became useful. The question Philip asked at the hearing, the question about whether any contemporaneous evidence of the deed's existence could be produced, was a question about this specific absence. Where is the evidence that this document existed in the 3 years between when it claims to have been created and when it was recorded? A real deed leaves traces. The grantor knows they have transferred the property and acts accordingly. The grantee knows they own the property and acts accordingly. There are tax implications. There are insurance implications. There are conversations. There is something. In 3 years, there was nothing. No evidence. My father had refinanced the property and filed a TOD affidavit and continued to pay taxes on it and continued to maintain it and continued to treat it as his property in every way the record reflects. Because it was his property. It remained his property until he died. The record said so. The record was right. I also want to say something about what happens when a fraudulent deed is recorded and the estate is opened and a title company searches the property. The title company finds the deed. They also find the TOD. These two instruments conflict. The title company flags the conflict, and Alice was notified because she was the attorney managing the estate, and because a conflict in the title chain of a property is exactly the kind of thing that estate attorneys need to know about immediately. Alice had called the estate's title company the same day she was notified. She had the full picture before I called her. The system had been designed to catch exactly this kind of problem, and the system had caught it the same day it occurred. Alice was ready for my call. Philip was the next call. The response was coordinated before the first hearing was scheduled. Good legal systems are built to catch the thing that does not fit. It did not fit. They caught it, sent me the photograph. I had expected the recorder to confirm it was there. What I had not expected was what came next in the index. The mortgage entry was there, and its date was after the deed's stated date, and I stared at that entry for a moment with the specific quality of someone who has just found the number that does not add up, and who understands with complete clarity why it does not add up. A mortgage against property you allegedly gave away 18 months ago. I wrote the dates down. I kept scrolling. I found the TOD affidavit. I wrote its date down. I looked at the column of dates on my notepad. I understood what I was looking at. I am an accountant. When the numbers tell you what happened, you trust the numbers. The numbers told me very clearly what had happened. The numbers were in the public record, and they were not going to change. I also want to tell you what Alice Fair said when I called her the morning after the text. She had already known about the deed from the title company that had been notified in the context of the estate administration, and she had been expecting my call, but she had waited to hear from me before reaching out, which I later understood was her specific way of letting me find what I needed to find before she told me what she already knew. Because attorneys who do estate work in small counties have learned that the clients who come to them already understanding the situation are the clients who are best positioned to help themselves. She said Philip will be the right attorney for this. She said Philip has handled cases like this before, and he knows what the sequence of instruments establishes. She said your father's TOD affidavit was properly prepared and properly recorded, and it has been in the recorder's office for 18 months, and it says what it says. She said the deed will be a problem for whoever is presenting it, not for you. She said, call Philip today? I said I will. She said, I know. She said, I am sorry about your father. I said, I know. I said, I am too. We talked about him for a few minutes, and it was the kind of conversation about a person who has recently died that is both ordinary and significant. Ordinary because you are using the present tense and talking about someone you knew, and significant because you are aware that the things being said are the things that remain. I want to tell you about what I found when I went to the farm for the first time after it legally became mine. I had waited 3 weeks after the ruling before going because I had needed the time to finish the other estate matters, and because I had not been sure what I would feel when I got there, and I had wanted to be ready to feel it. I drove from Worcester on a Saturday morning, and I arrived at the farm at about 9 o'clock with the specific quality of September in Wayne County around me, which is the quality of the very end of the growing season when the fields have the fullness of the harvest that is coming, and the light is the particular lower angle light of September that makes everything seem slightly more defined than it does in the height of summer. The farmhouse was locked. I had the key. I stood at the door for a moment before I unlocked it because I wanted to mark the moment in some way before I went in. Then I opened the door. The farmhouse had the quality of a house that has been in the same family's care for 39 years, and that shows the continuous investment of someone who understood that a house requires maintenance and who had maintained it accordingly. The kitchen was clean and organized. The living room had the furniture that had been in it for the last 20 years, positioned the way it had always been positioned. The office was the office I want to tell you about the farm's outbuilding and what it represents. The outbuilding is where my father ran his equipment repair operation for 30 years. It is a large metal building to the north of the farmhouse with enough floor space to bring full-size farm equipment inside for service, and with the electrical infrastructure and the lighting and the tool storage of a working shop. My father built it in the second year he owned the farm, and he added to it twice in the following decade as the repair work grew. The outbuilding has its own section in the filing cabinet, separate from the farm records, with the records of the repair work and the customers and the parts orders going back 30 years. Everything is there. The history of the business is complete and accessible. My father kept both sets of records, farm and shop, with the same discipline, because to him there was no difference between the farm records and the shop records and the legal records. They were all records. Records told you what had happened and what the current state was and what you were responsible for. He kept all of them, and he kept them right. The outbuilding is still organized the way he organized it. The tools are in the positions he put them in. The filing cabinet in the farmhouse contains 30 years of the history of that work. It is waiting for whatever comes next. I had always known, with the filing cabinet in the corner. I went to the filing cabinet first. I opened the legal documents drawer. The farm transfer folder was in its position. I took it out. The TOD affidavit was in it, my copy. The copy that had come home from Alice's office 14 months before my father died, and that had been in the folder where it was supposed to be ever since. I held it. I thought about him putting it there. I put it back. I closed the drawer. I went and made coffee in his kitchen and sat at his kitchen table and looked out the window at the north field for a long time. I want to say something about the specific legal argument that Philip made about the TOD affidavit and why it was, in his view, the most direct piece of evidence about the deed's inauthenticity. A warranty deed, when validly executed, transfers ownership of property from the grantor to the grantee as of the date of execution. After a valid warranty deed, the grantor no longer owns the property. The grantor cannot mortgage it because you cannot borrow against something you do not own, and the grantor cannot execute a transfer on death affidavit designating someone else as the beneficiary because only the owner can execute a TOD affidavit. These are not technical points. They are basic statements of property law. When my father went to Alice's office and executed the TOD affidavit, he was doing something that the owner of the property does. He was designating what would happen to his property after his death. If the deed had been valid, he had no property to designate. He could not have executed the TOD affidavit. Alice could not have prepared it for him as the owner of the farm because he would not have been the owner of the farm. But Alice did prepare it, and my father did execute it, and it was recorded, and the recorder accepted it. The recorder accepted it because the title search found him to be the owner, because the deed was not there. Because the deed did not exist, when I want to say one final thing about my father and about what he left me that goes beyond the farm itself. He left me a filing cabinet with 39 years of records. He left me the understanding that keeping the record is the work that protects everything else. He left me the TOD affidavit in the folder where it was supposed to be, and the folder in the drawer where it was supposed to be, and the cabinet in the office where it had always been. He had built those habits over 39 years of farming and running a repair shop and maintaining a household and managing his own legal affairs. And he had built them not because he was worried about fraud or dispute, but because he believed that knowing the state of what you are responsible for is part of being responsible for it. The records were how he took care of things. The records were how I was able to protect what he intended. He had not anticipated Garrett or the deed or the Tuesday afternoon text. He had built the system that made the response possible without knowing a specific response would be needed. That is what it means to keep records right, not knowing you will need them, keeping them anyway, making sure they are complete and correct and in the right place and dated. The dates were in the record. The record was in the cabinet. The cabinet was in the farm. The farm is mine. He left me the whole thing. The whole thing is in order. That is what he would want. I intend to keep it that way. The TOD affidavit was executed. The TOD affidavit was not just evidence that the deed was fraudulent. It was evidence that the person who created the deed understood that he needed to date it before the TOD affidavit to make the story work, and that in dating it before the TOD affidavit, he created a timeline that the TOD affidavit and the mortgage together made impossible. I want to say something about the 39 years of crop yield records in the filing cabinet and what they represent. My father had started keeping them the year he bought the farm. The first entries are in a spiral notebook, and the handwriting is younger than what I remember from my childhood, which is itself a specific thing to notice about a record that starts 39 years ago. Over the years, the system had evolved and the records had become more organized, eventually settling into the tabular format that filled the last 20 years of folders, field by field and year by year, with the yield and the crop and the inputs and the weather notes that my father had considered relevant. 39 years of information about how that specific land had performed under his specific management. It is an archive, not of legal decisions, but of professional attention. He had paid attention for 39 years to what the land was doing, and he had written it down and he had filed it in the correct drawer. The legal records were kept the same way and with the same care. The TOD affidavit had its folder, the folder was in the drawer was labeled. He had known where everything was because he had put everything where it was supposed to be and kept it there. There is something I want to say about Garrett that I want to be precise about. I have spent several months now trying to understand what he was thinking when he did what he did, and I have arrived at a version of the answer that I can hold without it consuming everything else. He had been present when my father's decline became visible, and he had been the person who drove my father to his appointments and helped him with the farm operations in the last 2 years, and he had done this with what I believe was genuine care for my father as a person. What he did with the deed is not consistent with that care, but I think it came from a place that was not purely predatory. I think he told himself that he had been the one who was there, and that being there should count for something in the disposition of the property, and that the formal legal documents did not reflect the full weight of his contribution. I think he told himself a story about what my father would have wanted if the question of relative presence had been factored in differently. I do not think this story is true. I think my father's TOD affidavit says clearly what my father wanted and when he decided it, and that the decision was made with full awareness of who had been present and how. But I think Garrett told himself the story, and I think it is possible to understand how someone tells themselves a story like that without agreeing that the story excuses what was done to tell it. I want to be clear about something regarding the farm and what I intend to do with it. I am an accountant. I am not a farmer. I did not grow up on the farm the way someone who intends to farm it would have grown up. The farm's future is a question I am approaching carefully and without urgency because I have the farm, and because the decisions about what to do with it are mine to make at a pace that is consistent with making them well. My father left me the farm because he wanted me to have it, not because he had specific instructions about what I should do with it. He left me the filing cabinet too, with 39 years of records that will help anyone who takes over that land understand what it has done and what it needs. The records are complete, the farm is mine. What happens next will be its own story.